కొంచెం బొగ్గు దగ్గర అవుతులే కానీ
I am audible, sir. Please unmute yourself, sir. I am audible, sir. Can I share PPT? Chandan, sir, your voice is not audible. Please unmute yourself. సారీ. ఓకే, ఇప్పుడు వినిపిస్తుంది సార్. నేను వినిపిస్తుందని మొత్తం చెప్పేసాను. ఓకే. Good morning, one and all. Thank you for giving a wonderful opportunity. Especially thank you, Sri Vasavi Institute of Engineering and Technology Management, and especially thanks to your friend Chandra Suresh along with the staff. Thank you very much. Today, and mostly, thank you very much, Principal Sir and Vice Principal Sir and academic and administration staff. Thank you very much. And today we are discussing the present topic is intellectual property rights, IPR for academia and industry startup. My name is, you know that, Bosubabu Sambana, innovator of Internet Protocol version 16. After IPv4 and v6, I created IP version 16 and working as assistant professor, associate professor. You know that this is my website. Please go through if any details is required. Then the present topic is intellectual property rights. What is the intellectual property rights? For specifically used in for academia and industry requirements. How the industry requirements, then how to convert the academia transform into industry, and industry the basement is startups, how the patents will transform into startups. Then if you have any idea, then how to convert your idea into startups. Another one, if you have any trademark secret, if you have any copyright, if you have anything like intellectual property right, how to utilize properly through proper channel. In this session, we will know completely about all details. The present topics we are discussing about introduction to IPR, what is IPR, and history of IPR, and how many types are there. Generally, you know that patents, copyrights, trademarks, and geographical indication and trade secrets. And what are the historical perspectives and evolution of IP laws and Indian IP laws? In fact, in the point of IP, how Indian government supports for new innovation challenger minds and curiosity minds, how the fees reduction will given for total fee of they give 90% of reduction for education institutions, and what is the international patents and national patents, and what is the international PCT, and if you have time, we will show on how to file a patent in Indian patent and an international patent, and how to file a copyright, and what is the process, and what is the trademark, and how to file, and what is the trade secret, and how to file a geological indication also. And the main thing is a national IPR policy. Then what is the intellectual properties? The intellectual property, generally, you know that if you have any idea, then simply you go and file a through proper channel like commercial way and non-commercial way. In the way, the what is the intellectual property rights? Intellectual property rights means creation of human mind to create innovation thing, and knowledge assets created through the magnification of ideas, innovative ideas, not copied ideas. And here, innovation is different and discovery is different. Conferred on creators as exclusively situation rights for intangible knowledge assets for particularly innovation made. And tradable commodities like any other right, like copyrights, trademarks, like this. IPR enforceable by specific law. If we have any mismatches, if we have any distributions. If we have any copyright issues are occurred, then one institution also there. Intellectual property appellate board also there. The entire body, statutory body maintained by Minister of Law and Department of Commerce and Industrial Promotions, and the website is ipab.in. Another one, IPR play more important role as assessed for enterprises than physical assets. The what is the another one tool for business competitiveness, and another one, IPR new wealth for nations. Why? Because it creates a new generation of jobs, new generation of economy, new generation of platforms also. Then you know that national and international dimensions of IPR. Generally, IPRs are completely maintained by government of any government, not particular state government. The completely IPR rights maintained by government of India in India. In other way, government of Australia and European government. European government covers under nearly 30. European Union covers nearly 30 patent offices in one under one roof, and WIPO also there, and patent scope also there, USPTO also there, US Patent Office also there, and in countrywide, the national and international policies also there. They maintained qualitative agreements and protocols also. In here, international conventions also there, Mandarin conventions, Paris conventions, and so many conventions there. Laterally, you know that ensures minimum rights and provide certain measures for enforcement right of the contract states, defense states. Before going to that, what is patent and what is designs and what is trademarks and what is geographical indications and what is copyright, and laterally you go that. Then before going to that, just small introduction about patents, copyrights, trademarks. Laterally, we will discuss in very deeply manner. Generally, patent is a statutory body guided for innovation, for it not copied anyone. If you copied anything, they set it into patent scope and patent database. If you are malpracticing anything from the other copied works, like classification as required, or any things are mapped, they sentenced, and immediately judiciary you take 7 to 20 years. Half is assigned for limited period of time. For granting date of filing, it is nearly 20 years of filing date, excluding others from making, using, offering a sale, selling, or a technology transfer or commercialized need for any product covered by the patent. It is generally patent is a process. The process is initially in problem identification, laterally problem definement, laterally filing a patent and publication and examination, laterally granting state, laterally renewal state. Laterally, in between communication, technical transfer also there, commercial needs also there, and if you require some withdrawal policy also there, based on say various criteria, patentable invention categorized into various factors. First one, we must know the novelty of the work. Second one, inventive step. Here, inventive step is clearly mentioned in the examination purpose. If what is the requirement to, what is the new thing to create, to give the your product may be copyrighted. The entire question given from the intellectual property rights office. So the first thing is novelty, and innovation should not from a part of state of art. It's completely new innovation thing, not discovery. And invention step is also used in like commercial way. At the same time, at the end of the patent granting examination process, they completely asking invention step and deduction step, indirect step, and next one commercial and capable of industrial application. Generally, 9 types of applications also there. Order application, conventional application. So many applications also there for filing purpose. What they are required for your based on your requirement, you go through based on seven types of applications. First one go through initially provisional application, and second one complete specifications. If you have any idea, then you must register without any proper work. Go through site and apply through any proper channel, commercial way, or any consultancy through. Go through the filing um, provisional application. The provisional application duration is nearly 12 months. Before 12 months, you must go if you want to extend your work, and then the up to valid 12 months of your patent number. After that, the patent before expire of your patent number, you must file a complete application. Then immediately the extension of your work um, comes under complete specification. It is completely valid for 20 years from the date of filing or priority date. Here, priority date completely based on classification mapping. And another one, designs. Designs means shape and configuration, pattern, ornaments, or like chapels and bottles, whatever it may be. Any kind of thing may be considered for design patents. We will deeply discuss in a manner. Design does not include any mode of physical principle and mathematical formulas or construction or anything with substance of mechanical device. Here, the main thing is mechanical device. Also, some cases 4-2 classes, they are acceptable based on agricultural activities, and it is completely valid for 10 years. And maybe if you want require renewal your process, renewal your patent, maybe extension 5 years and more. After that requirement, you need to add more 5 years where for pay fee some extensional fee by using for some forms. And industrial designs are the great commercial value because of shapes or configuration of article can often be a great selling point. The main thing is bottle, water bottle or cool drink bottle, any kind of bottle is a commercial value. And trademarks, generally you know that I have all rights, patents, copyrights, trademarks, all those things I have. I will show you everything including certificate grants also. Please wait. And what is the trademarks? Trademarks means a mark of capable of being represented a graphical or any indication of any indication of signals like Allu Arjun sign is a trademark. Okay, AA is like a trademark, which is capable of distinguish the good or service one of the person from those of the other. May include shape of fruits, their packaging, and combination of colors. Here, the maintained and the database maintained by Indian Institute of Packing and Trademark Designs, and the trademarks can be signed like allergen sign, words, letters, numbers, drawings, pictures, emblems, and most of the case, our institution logos also. We will if you want to require design your institutional logo also present some criteria and some application process there, and colors, combinations of colors, shapes, and sounds. Here specifically sounds is different, music is different, or any music is copyright, or any combination of the above applied to the goods or services. It is completely valid for 10 years. maybe thereafter renewable property for them nearly 10 years. If you are required after 10 years, pay some fees through renewal application process. And another one, geographical indications. You know that geographical indications, Kundur Kadi and Madanapalli mangoes and Tirupati Laddu and Palasa cashew and so many there, so many, and Kanchipuram Kanchi Pattu, Dharmavaram Pattu, so many things are there. And Rajasthan, Jaipur also famous for handlooms. Geographical indications, it's generally it's represents and identified agriculture or natural or manufacturing goods are assigning or manufacturing in territory of a country or region or locality in the particular territory where a given quality. What is the main thing to geological indications are required? The main thing is it's create a quality of product and reputation of and the characteristic of the your product and particular area also. You clearly mention, you clearly known about the particular area, that area belongs to that product. And here prevention mechanism also there, some what we call unauthorized dummy tools also available in the market. Before going to the purchasing handlooms, any trademark and the geological indications, before go through proper verification, and it is completely used for promoting and economical prosperity and uh, create new opportunities and particular areas and for geographical identification. And you know that what is the corporate? Generally, corporate is a right of any artwork. It is generally categorized into literacy and dramatical music, artistic works, and cinematographic films, and sound recordings. And this is the so many factors are there. Copyright does not ordinary product titles, names, and here titles, names comes under trademarks, short words, combinations, slogans, and short phrases, methods, plots or floral information. These are not comes under copyright policy due to some internal uh, acts are there, IP acts also are there. Due to various factors, so we consider the what is the duration, original address work, dramatical work, music, artistic works, and cinematographic films, sound recordings, music, and photographs, and publication. Our publication, here we are all faculty and students also. We are planning to publish our papers through publication channel. Publication house or organized publication company have publication rights, but author have copyrights. But unfortunately, sometimes publication house definitely and um, surely they ask for copyrights from your end. Why? Because if any publication comes under plagiarized, any misconduct has occurred, you are completely responsible for this. This is the completely mind mapping mechanism for publication purpose. Every publication houses it must maintain this kind of copyrights mechanism. And what is the broadcast reproduction right? And generally utilizing TV, braille, TV mm, broadcasting rights and performance of rights. And I will show you. And what is the historical perspective of IPR? Here, early use of marks, early use of sign, the Chinese parts. You know, everyone see. like these parts in Chinese movies, Kung Fu Panda, 1, 2, 3, and any innocent movies. We are see in these parts. The Chinese parts explicit two types of marks. First one, period of emperor and name of the mark or place of the origin. And the second one, the use of stamps on bricks by the Roman um, brickmaker for the purpose of identification began early 2nd century BC. Here some of the some of the artifacts and some of the legal issues are occurred during the 2nd century BC. In a way, they used some uh, categorical identification about structured stone and brick. Those are categorized into two factors. And potter's mark of Greek and Roman types appeared in vessels indicate particular origin, destination, along with identification of marker. And second one, the finest example of the barber's pole in our India. And during 10th century, merchant's marks also referred as a property mark was used to prove ownership rights of the goods. And latterly, the first English Parliament entered a law in 1266 for every baker shall have a marker of his own for each sort of bread in each order. Why? Because already so many breads companies are available in the market. They are copied and they are utilized their they are utilized their work without any proper rights, proper permission. In the way, the king of the judiciary released one order in 1920 in 2066. They give the particular right. Latterly, 13th century, copying of value marks became so common, injuriously, that infringement was made misdemeanor and some cases even felony. In 14th, 15th centuries also, so many crafts and trademarks like symbols, logos, began. Many more, Leonardo da Vinci also used so many patents, nearly 500 patents. The one of the book also saw the La Da Vinci Code. It is completely copyrighted. And Southern versus how in case 60s, 70s. Laterally, the British government gives Trademark Act 1875. For the registration was considered for evidence of ownership of the trademark. And coming to the main point, how to file a patent. At right now, we are going to the filing patent nearly 2000. The Indian government goes on digital way. Before going to that, the entire patent system completely paper, offline mode. In the way, before going to that, in early patent system, how the patent will be patents are filed, how the patents will mark the particularly that belongs to this one, the particularly this idea belongs to this one. Nicholas Tesla have nearly 360 patents. Then with that day, no digital that one, no digital system is there, and Albert Einstein have nearly 45 to 60 patents are there. Then how to they recognize it? And so many things also there. So Nagarjuna Saha and Sachinandra Bose, so many researchers also there. Then how to they file a patents? What is the mechanism that they are using? The main thing is generally the patent is originally meaning as open, means to use all, and the the letters are patents, meaning official documents are open letters. By letters patent certainly prevails rights, ranks, and honor or title were conferred and publicly announced. In the way, the grant of patent based on two factors. First one, individual grant and group grant. Next one, industrially or any institutionally file or any commercial companies also plan to file. I'm audible, sir. I'm audible, sir. Hello, I'm audible.
Yes, sir.
Thank you.
Hello? Sir, audible.
Okay, thank you. Please unmute yourself. Thank you very much. Next, earliest example of patent system. In in 510 BC, Greek cities of Cyberis. One major problem also there at the same of thing. They don't have any digital system. They don't have any physical paper mechanism. The main thing is that day the food is main thing. That early days in BC 510, the food is the main thing. In one, if the one cookie is cooked like barber, like bread, one cookies invades delicious food, new dish. No one can copy it. No one can copy it. With the no one can copy it. No one can use their formula, their same taste, and so many things. It is completely writes nearly 1 year. After that, the thing, the who are cooked invents the particular food item. It is openly available for all. That this is the first innovative patent mechanism. After that, after that, the first patent, the early English patent was granted by Henry VI in 1449 to John Putnam, a glassmaker. The completely glassmaker laterally gives the some of the orientation classes and then how to create a new glasses with the existing mechanism. Then the glasses mechanism laterally comes give a big revolutionary mechanism in optical fiber, optical in physics section, so that he could share his technological secrets with the appearances without fear of competition from them. For the maintain the granted for making stainless glass for window of Eton College, the process previously unknown in England. The king commanded that none of his subjects could use such arts for a term for 20 years without consent of John. This is the first patent in history. Before that, we are going to the without proper identification. But in technical way, 4049, the first patent received by John Putnam. Duration of his patent was 20 years. In return, he was required to teach the process English glassmakers. Laterally, it is absent when laterally this mechanism utilized in space research. So many cases. The first Italian patent was awarded by Republic of Florence in 1421 to architect Filippo Bergens, who found in some difficulty in bringing the heavy stones over the river of Arno into Florence for his work construction of massive dome for the Cathedral of Florence. Next, veteran patent acts. So many patent acts also there. First one, invention, incentive, and requirements. And and everyone knows Galileo Galilei patent request in under Veteran Patent Act here, Patent Act 1474, Galilei discovered one thing like pump, the pump machine. Irrigation pump machine, the first innovation of Galileo Galilei. Laterally, he invented telescope and so many things. But the first innovation of Galileo Galilei is irrigation pump for agriculture requirements. The these things laterally, the its thing in 1474, laterally they gives 40 years of periods of grant. Laterally, uh, laterally, no one can break the history. This is the one of the uh, world history also. And another one, patent granted to Galileo Galilei in patent device for raising water for academic, sorry, for agricultural needs. And the UK United Kingdom Statute of Monopolies from 90s for 6023 to 624. So many problems also there during this time. And Turkey and Allen, some cases also there. Some you know that already earlier things we discussed. Patent appellate boards also requirement based on this non-judiciable and judiciable arguments are requirement. And corporates, for history of corporates in 557 AD in Ireland, Saint Columba invented write a book, but his scholar without their permission directly publish without his name. This is this thing. The first filing the copyright, first process of copyright, along with uh, first judiciary revolution in copyright policy. Laterally, so many things are there. The first things of first copyright followed by Saint Columba, and so many things are there. And IPR laws in India. First IPR granted. Hello, I'm audible.
Yes, sir. Audible.
Okay, everyone knows patent filing and trademark filing and design filing, but all are comes under one roof. That is the Controller General of Patents, Designs and Trademarks, CGP TDM. The website is ipindia.in, ipindiaonline.in. The way before going to that, the various acts also there. The first Patent Act in 1970 with some amendments, and laterally two trademarks acts also there in the Trademark Act 1999 and Geographical Indication of Goods Registration Production of Act in 1999 and Corporate Act in 1957 and Semiconductor Integrated Circuit Layout Design Act in 2000. Before going to that, you know that patents, designs, trademarks, and so many things also there. But semiconductor chips also there, VLSI technology also comes under patents. This is very fabrication thing. Uh, the entire thing maintained by ministry of various ministries for a various purpose. The if any judiciary revolution judiciary problems are occurred, the entire things are maintained by uh, statutory body. Already you know that the main thing, the body is um, Intellectual Property Appellate Board, IPAB.in. The thing maintained by the statutory body maintained by Department of Law. And another one, Ministry of and Foreign, Ministry of Environment and Forests, where the you if you want to file a patent, you must uh, choose one option. If in this innovation, if any biological indication as used, any any animals are used, any things are used, any human bodies are used. In this case, we are must you must permit from the Biological Diversity Act through Ministry of Forest, Ministry of Environment and Forest. Another one, if you have any design-oriented patents going to that filing, then the thing is maintained by Department of Agriculture and Cooperation. The complete maintained by uh, the Production of Plant Varieties and Farmers Rights Act in 2001. But if entire patent system, corporate trademarks, and the comes under Control General of Patents, Design and Trademarks, maintained by in the Ministry of Industrial Promotions and Commercial, and this is the thing. This is the body of the IP and evolutionary of IPR in India in milestone and evolutionary IPR laws in India in 1856. British government creates an opportunity. Before that, 4077 and 4066, later 8080, 1888 and 1999, they give establishment of IPs of controller and patents increase terms of initially terms of 14 years to 16 years. Latterly, the Indian government first create Indian Patent Act in 1970, the term of 14 years and 99 TRIPS obligations also there. If any duration the filing process and copied version, so many things are there. These things are occurred during the filing process, copied versions, completely maintained by government of India and Copyright Board. And 2002 especially introduced 18 months publication, early publication, uh, 18 months publication, laterally use the early publication, 2005 in opposition system and trademarks till 1940s, and they design from British government given the Patent and Design Acts uh, and latestly 2001 Design Act and Geographical Indication Act and the Corporate Acts in 1940s, 1914 to here semiconductor and semiconductor integrated circuit design layout. Here semiconductor integrated circuit layout design act was added in 2000 due to provide production for semiconductor integrated chips layout designs and post independent developments and various acts also there. Current features here Industrial designs was separated from the Act. Elaborate definition of innovation. No product patent available for food, drugs, medicine, including the product of chemical process. Codification of certain invention as non-patentable, like algorithms, is completely copyrighted. Okay, mandatory furnishing of information regarding foreign applications, how to file a foreign patents. I will show you, no worry. And terms of patent reducing from 16 years to 14 years. Laterally, some industrial requirements purpose, it's extended to 20 years from the filing date. And in terms of patent for the process, drugs, foods, maximum 7 years. If requirement, government empowered to use innovation for its own use by using some places. Okay. Then we will go to in discussly. Visible?
Yes, sir.
Before going to, already we are discussing some brief information about what is patent, what is trademark, and what is like copyright, and what is geographical indication. But we are the right time, we are discussing in detail what is intellectual property rights and what is how to it utilize in proper way and how many types are there. If you have any idea, if you have any idea, then we are going to the before we are going to through proper way. Intellectual property rights, intellectual property law protects the results of human creative endeavors like writers, inventors, and artists transform ideas into tangible property like commercial property way. When this intellectual property qualifies under law, IP law, and the creators granted certain rights. The even laws also provide some specific lawyers like criminal law, like this, criminal law and civil law, like similarly patent law, like IPR law. And based on various factors, classification of categorized into three factors. First one, mobile property and immobile property and intellectual property. The immobile property in civil law systems, buildings, personal properties is often called mobile properties. These comes under registration parts also there, based on some specific states also there from mobile properties for registration purpose. Second one, immovable property. Here, immovable property means is is an immovable object in items of property that cannot be moved, but without destroying or altering it properly, that is fixed to earth, such as land or house. Another one, intellectual property rights. Here, intellectual property rights refers to creation of human mind, like innovation, such as invention and literacy works and architecture works and design, and already you know that design patterns, symbols for trademarks and shapes, names and images, and used in generally in commerce are like commercial way. And the main thing is generally meaning ideas and creators of mind. Like curiosity minds creates innovative thoughts having commercial value are called IP, generally called as a intellectual property. The intellectual property legal rights associated with the legal rights, innovation rights, legal rights associated with the intellectual property, generally called as a intellectual property rights. And the basic purpose of intellectual property rights is to recognize based on your works, like rewards, efforts, and also to protect such as efforts from wrongful use by making in legal offense. If already we are discussing in the way you have patent, but someone using and commercializing and technically and non-technically they are not permitted by you to permit not given permission from your end, they utilize it in the way they are easily your file your file your pay against their works, then you you want to ask anything like royalty or completely the product also the completely product also in your hand. Why? Because the entire property belongs to you only. That things it is not mobile property and immobile property. It is completely intellectual property. Based on intellectual property laws and rules and regulations and acts, the you are the innovator, you are the proprietor, you are the performer, you are the owner of the work. No one can defend without your work. Okay, then definition wise, according to the WIPO already we discussed intellectual property organization. This intellectual property organization manages entire mm, entire countries, entire globe. All countries comes under WIPO. If you want to file a intellectual, if you want international patents through one country to another country, go through WIPO. Okay, as some case, another way, some specific IP offices also there. But if you want to file in India, then the same patent file in another country. But you are directly filing in country in India, in US or UK. But the fees are too much more. If you file in India, then go through. If you file in India in your patent in secured with the patent right, patent number, then go through WIPO PCT. Then it is very nominal prices, and some some economically weaker section countries they give some reductions also. The 90% fee reductions also available. Okay, according to the WIPO, IP refers to creations of IP, creations of mind, such as inventions, literacy, and artist works, design, symbol, names, and images used in commercial way. And intellectual property rights generally refers to the general term of assignment of property rights through patents, copyrights, and trademarks. These property rights allow the holder of the work to exercise a monopoly on the use of item for a specific period, like duration of the granting period, 20 years maybe, design patents 10 years. And what are the features of intellectual property rights? The specific thing is documentation. You must know the documentation. What is the documentation? How to write a if you want to file a patent, you have idea, but how to write a draft? The drafting procedure also there. Field of invention, Next, introduction, objective of the invention. Next, background of the invention. Next, uh, detailed description of invention. Next, working procedure of invention. Next, diagram of invention, detailed description of diagrams, and abstracts and claims. This is the procedural way. Based on your work, based on your filing way, either complete specification, either provisional application. Based on the requirement, the application application along with documentation also changed. Another one, legal authorization. If you want filing through any company, you must file a non-disclosure agreement (NDA), and the form is file 12, form 12. And description, in detail intellectual property, whether it's a trademarks or patents and copyrights, and ownership. Identify the owner of the registration. Here, two things you must remember. Innovator is different, applicant is different. Here, applicant, if you want to file a application through any commercial, through any consultancy, those are comes under applicant. Along with you also, second one, applicant. But innovation grants comes under only owner. That means innovator who are belongs to the work, the completely the rights belongs to the particular work, generally called as a innovator, form 5. And time duration, intellectual property have the specific time duration based on the property. Like filing, immediately you need to file, and the filing is after filing. If you want to come early publication, if you want to come early publication, go through form 18. Form 18, fees is 2,500. In the general fees is form 1, 1,600 rupees. This is the government fees. 1,600 rupees for application fee. And laterally, if you want to publish your article early, that comes under early publication. The early publication fees is 2,500. After that, the early publication after verification, they give some classification along with mapping procedure in patent database. In the way, they give publication document. The publication documents means not a grant. Not a grant. This is opponent of the work. The publication means who are similar this kind of work. Please verify your end, give the option, raise your work to opponent. If any kind of work similar to or copied your work, then they give comes under similar pay. Then the every Friday, government of India through CEPTM, Indian Patent Office release patent journal. Every Friday, patent journal will be released. The patent journal patent journal contains number of patent documents like a patent number. I will show you everything. No worry. Laterally, the early if you need no need to early publication, then the publication comes under 1.5 year, 16 months. Sorry, 18 months. After that, if you want to early publication, laterally if you want to early granting procedure, go through early examination process. The early examination process is form 9. The fees is 4,000 rupees per government. Here two things also there. First one, highway process application and normal process application. Highway process application, in nearly every month, 100 patent applications are filled first come first service based with a field. Here one thing, in your patent application, any woman is there. One option is there, nearly without nearly within a month, within a year, patent will be granted due to women's in IPR in the policy of government. Within a year after filing of at the filing day, and granting date is nearly one year due to women's in IPR policy. And fees also are there. Already told you, every forms it's gives the particular fees for filing form 1, form 2, form 3, form 4, and up to form 5 is innovator, and form 30 and 31. Form 30 is what we call form 30 is examination reply. And commercial value, intellectual properties have commercial value. It means we can sell and buy and technology transfer and anything. Importance of the intellectual property, enhancing of probability and business strategy. It is crucial to success in the marketplace and more useful to the manufacturing sector like industrial infrastructure sector, and useful for competitors, useful for customers and economy development of every country. You know that early basics of intellectual property rights. And what are the objectives of patent law? Absolutely, protection of your work and wonder of your work, and financial incentives and economic growth and increasing monetary value and morality also. Generally, I am audible.
Yes, sir.
I am audible.
Yes, sir. Audible.
Okay, thank you. Generally, the major types of intellectual property rights. Generally, we know that so many cases, patents, trademarks, so many factors, but these are categorized into three factors. First one, functional and non-functional and technical inventions. Second one, purely artistic works. Third one, a symbol, logo, word, sound, color, design, etc. Based on these characteristics, the category government of India categorized into three acts. The first one, Patent Acts and Copyright Acts and Trademarks Acts. Geographical Acts also there, and Semiconductor Acts also there. Okay, and organizing structure of filing mechanism. How many patent officers are there? Yearly organizing structures. First one, the entire patent design trademarks all are comes under one department and one ministry. Ministry of Commerce and Industrial Promotions. Um, the department is Department of Industrial Policy and Promotions. The gives comes under they maintain one statutory body, controller the Controller General of Patents, Designs and Trademarks. These are categorized into four factors. For geographical indications based, they located four offices. First one, uh, Kolkata, Delhi, Mumbai and Chennai. We are comes under Chennai Patent Office. South India, North India and East India or West India. Okay, these are here patent and design offices also are there. Kolkata, Delhi, Mumbai and Chennai. Initially, in early days, patent numbers are comes under DEL, CHE and MU and KOL slash year slash number. This is the patent number, initial days. Laterally, 2020, 2020 August 15 onwards, government gives the unique number. First one year 2021 and 410 and 410 next office number, next patent number. This is the um, newly designed patent number, and it is completely mapped with international standards. Okay, another one, trademarks office, trademark registry office are Mumbai, Kolkata, Delhi, Chennai, and Ahmedabad. You know that geographical indication registry like Tirupati Laddu, whatever it may be, Lord Balaji, Tirupati Laddu, and Pondur Khadi, and Rajasthan, the Jaipur food, whatever it may be, like Chennai. And the main thing is patent information system. The patent information system, any technical issues are occurred, the things are maintained, the team in Nagpur. The entire process will maintained one institution like IIT, Rajiv Gandhi National Institute of Intellectual Property Management. Okay, then we know that the types of intellectual property rights. First one, patents for innovations, and corporates for creative artistic works and software works, and trademarks for marks used in business way, and industrial designs for the external shape of the product, like a water bottle, whatever it may be, and layout design of integrated circuits through the Specification Integrated Chip Act, IC Chip Act in 2000, and geographical indications for goods from particular region or territory, like Darjeeling tea, like Pandur Khadi, and Palasa Jeedipappu, and Jaipur Fort, and Putturu, something, and plant varieties for creating new varieties of plants like hybrid plants, and trade secrets for information of commercial importance. Here, in Coca-Cola, liquid is Coca-Cola liquid is trade secret. Like bottle is bottle is design. Coca-Cola design is trade secret. That is what Coca-Cola design. Coca-Cola name design is trademarks. Sorry. Then types of IPRs. You know that intellectual property generally. These are categorized into two factors based on evolutionary factors: industrial property and corporates and related rights. Here, industrial property, first one, industrial designs, Coca-Cola, and patents, trademarks, and trade secrets, and geographical indications, layout design of semiconductor, ICs, and plant varieties, and farmer rights for agriculture design purpose. Here, industrial designs, bottle, and cap also comes under industrial design. Patents, like design patents, shaving machine comes under design patents. Trademark services, trademarks, Coca-Cola, and I'm moving it, orange, and R comes under trademarks. And service marks is different, R is different, TM is different, and trade secret. Here, liquid Coca-Cola liquid is trade secret, and geographical indications means chapels, and design also comes under patent design also comes under ornaments, and layout of semiconductor design means chips, and plant varieties and farmer rights means design of new varieties of hybrid, and corporates means comes under book. The symbol is C. And introduction to IPR. Here generally we are using everything, but what is design, what is patent, what is trademark? Here fan is patent. Here, um, our phone backside logo also there. These are called trademarks. And is in fan, so many designs also are there, generally called as a industrial design. Our working principle is patent, but design layout is comes under industrial design. Here, designs are categorized into three ways. And geographical indication is just everyone knows Bala Tirupati Balaji Laddu famous. And here know that cheppals, geographical indications also there, Kalhaburi cheppals, and the in bottle, Coca-Cola bottle and any cool drink bottle comes under complete IPR. The design of layout comes under patent, design patent. The trade secret is formula is trade secret, liquid formula is trade secret. The design of Coca-Cola is trademark. The industrial design of layout is industrial design. Then the main types of intellectual property rights is categorized into four factors. First one, um, copyrights, patents, trademarks, and trade secret. You know that in detailed manner, I will explain copyrights and everything comes under patents. Now we are going to discuss in patents. Patent is an exclusive right granted by the government to the original innovator or researcher developer of an invention, which prohibits others from making, using, selling the innovation. The patent grant of the grant of patent or exclusive rights over innovation encourage the people think creatively, and the complete rights belongs to the owner for beneficiary ratio. Okay, various factors, um, various acts also there. In Thomas Alva Edison ran electricity through an instant filament in 1879. He invented in modern light bulb, and what he got for it was a patent. Patents protect innovation. Here, Thomas Alva Edison nearly 1,000 patents holder. You know that Nicholas Tesla and Thomas Alva Edison disputes for alternative current and direct current principles of innovations of it is completely innovations of mm, Tesla, but due to his work done in industry, Thomas Alva Edison industry, in the way the work belongs to industry. Laterally, he implemented modern way. Laterally, Thomas Alva Edison direct current completely collapsed. We know that I'm audible. Hello?
Yes.
Yes, sir.
Oh, sir,
You know
audible.
that? Okay, thank you. You know that we know types of patents. These are categorized into three factors. First one, design patent and utility patent and plant patent. Design patent means here watch, generally called ornaments, watch, and anything like any design comes under design patent. And utility patent. Utility patents are those most common, and they cover process, machines, articles of manufactures, and compositions of matters. Okay. Third one, plant patent. Plant patents means plant patents covers newly developed varieties of plants provided by provided they can be reproduced sexually. That means create hybrid pattern, hybrid trees is the main thing. Types of patent applications. The mostly patent applications are categorized into 7 types. First one, provisional application. Second one, ordinary application. And non-provisional application are complete application, generally called as a ordinary application, and conventional application, and PCT, international application. PCT means Patent Cooperation Treaty. Is one of the it is one of the agreement also there, acts also there, patent PCT, generally called as a WIPO PCT, international application, and another one PCT, national praise application. Once you file in national praise application, laterally you want to file in international, then go to PCT international application along with another one application for patent edition. The patent edition means already you filed a patent in either provisional application, and a non-provisional application means complete application or order application. If you add more thing like your draft or add more innovators, anything comes under application for patent of edition. Another one, divisional application. This divisional application comes under industrial and promotion policy way. And requirements for patentability, first one, novelty and utility and non-obviousness and terms. Term, period of time. First one, novelty. Without novelty, you are so many companies and so many things also there. Already you know that author positions like that. Patent first position 3,000, 4,000, 5,000, 7,000. This kind of environment widely we are here nowadays. This is not a good thing actually. Why? Because they need only money. They need only money. If you want to patent and they immediately publish, if you are lucky, no one can oppose the particular thing. You are safely now. If anyone oppose, if anyone oppose the particular patent work, then you are completely, uh, completely arrest. You are completely comes under judicial way and non-bailable arrest warrant, and without any proper allegation, you must pay what their offer, what their ask, the completely amount you must pay. This is the main thing. So many companies are gives offers positions. I suggest to you strongly, no one do this. And term and utility must have useful purpose and actual work. The main thing is so many things also there, innovation patent and utility patent and application patent. Here so many things are generally used in like Arctic works patent. The one any fourth year patent, fourth year students works, any literacy works, then the literacy draft with patentable drafts and file immediately. This is without proper commercialization way. The patent is not used. This is the main thing. If you really have good work, then go to patent. Otherwise, it is completely judicial way. If you are lucky, you are safe now. If you are unlucky, at any cost, after your patent will expire, after that, after a few days, after a period of time, then you safe now. Until you take author positions, patent positions, 1, 2, 3 like this, we are suffer if they oppose anything. And the term is typically 20 years based on your work file when you filed the patent filing date. The elements of patent rights: exclusive rights over inventions, completely rights belongs to the innovator, and motivator of innovative engineers. And if you want to file in patents in India, we can get details ipindia.nic.in. This is the old website, ipindiaonline.nic.in, ipindiaonline.in. Okay, these are my patent grants. These are the design patent grants and normal patent grants. My patent grants, intelligent autonomous researchable power storage with water resistance walkable shoe. This is the patent grant. I secured patent grant from Government of India, and this is the intelligent artificial intelligent approach to single platform multi targets self-driven self-driven missiles with autonomous carrying system. This carrying system, this patent is also secured patent from Government of India. This patent is before getting the patent, me and DRDO opponent each other. This completely works belongs to me, and some questions also rises, some opponents and some distributions also occurred in IPA appellate board. Finally, I secured these rights, and this is the US patent grant and trademarks. I will explain everything. Trademarks: your name, logotype, symbol, slogan, and color. Trademarks: I will explain everything. No worry. Trademarks. When George Eastman come up with the name Kodak for his camera in 1883. In 1980s, this is a $300 billion company, Kodak. Later, so many innovations and image patents came. Kodak company collapsed due to various reasons, technical reasons. What he came with was trademark. Trademark include brand names, logos, slogans, and even product shapes, colors, and sounds. Choosing a trademark, a strength of a trademark varies in according to the generic name of the product and services, etc. Furniture and computer. Design also comes under trademark. And descriptive tells something about a product or services directly, like Airtel, American Airlines, and so many things, TCS, Wipro, and so many things. And suggested something about product or services indirectly. They gives particular brand image of your work or product or anything. And arbitrary, no relationship to product or services, like Amazon, Apple, Camel, and Dow, Shell, Virgin Communications. Here, trademarks, Yahoo. These are symbols, popular trademark symbols, trademark granted symbols. This is the industrial designs. It's nearly 15 years. Comes under ornaments, chairs, car designs, bike designs, and chapels. And our dresses also comes under industrial design, bottles, along with cup also, shoes, and industrial designs. Industrial design is important and has commercial value in case of certain goods where shape of matters and influence purpose purchase requirement purpose. Okay, based on in the Industrial Design Act 2000 was enacted by Parliament replacing The previous British Government Act, Design Act 1911. The Act may next layout of design of integrated circuits. Integrated circuit is a product having transistors and other circuitry elements which are inseparable from on semiconductor material or any insulating material or inside the semiconductor material designed to a perform an electrical circuitry function. It is first semiconductor act is a 1984 USA SCPA Semiconductor Chip Product Act. Later Indian government released 2000 and geographical indications like basmati rice, Darjeeling tea, Kanchipuram silk sarees, Alfonso mangoes, Nagpur mangoes, and Kolhapur chappals, and Bekaner Bahuja, and Agra Peta, and Tirupati Laddu also, Pandur Kadi, and Palasa Jeedipapu, and geographical indications. Here, geographical indication means the goods or products which are originating from particular geographical region or territory situation in particular country like Assam tea, Kanchi sarees, Nirmal paintings, etc. In India, as member of WTO, World Trade Organization, entered geographical indications of goods from Registration Product Act in 1999, which come laterally it's come TRIPS agreement. Plant breeds rights. These are legal rights granted by the government of India or any other governments particular or specific reasons to provide security or production of plant varieties. Rights of farmers and plant breeders. The completely once verification done through ICAR, Indian Council for Agriculture Research. The main theme of this aspect is inventors do not lose the benefit of honest effort in identifying medical values of plants extracts since the evaluation use and maintenance of plants is encouraged by the patent system. The evolution and evolutionary mechanism maintained by ICAR in Indian Council for Agriculture Research and trade secrets. The maintaining a trade secret is an indication of fair business practices. Already you know that. Yeah, trade secret. Liquid is trade secret. Trade secret. These are very valuable and uh, properties practices all the necessary means to protect them. Trade secrets require security. One thing on Raviteja movie also there. Raviteja, Sunil, and movies also there. In movie, Raviteja expired, but laterally 30 years, later 30 years, he is suddenly awaked. The movie is there. Mm, this is the mechanism how to evac the mechanism as called as a trade secret. The creation of company security plans may be a task in which the paralegal is involved. It's require execution of some special confidentiality or non-disclosure agreements between the employees and properties and owners and users also. It is independent consultants or other companies. Here, everyone must follow the non-disclosure agreement. These are mainly refer to the proprietary information having commercial needs to the application and value purpose. In India, though no exclusive legislation exists, but a matter would be covered under Indian Contract Act in 1872, later 1954, the Give Trade Secret Act. When well, when Dr. John S. Pemberton mixed together sugar syrup and other ingredients in 1886 to make a refreshing a new beverages, he came up with a secret formula for Coca-Cola. Coca-Cola trade secrets invented in 1886 with sugar syrup along with some ingredients. He kept it secret and protect it as a trade secret. Like one old people also there, like chicken. The chicken means old people, white guy people. Number, but the name is okay. I will tell you. High trade secret is information that provides a business with a competitive advantages. Business promotion is treated in a way that can reasonably be expected to prevent the public or competitors for learning about it, absent improper acquisition and theft. Trade secret examples a formula for soft drinks, marketing strategies, and manufacturing techniques, and computer algorithms and customer lists. Okay, please write. I'm visible.
Yes,
Hello, I'm visible
No, sir.
right now. Right now, I'm visible. Hello, Ma చెప్పండి. Visible or not?
yes, sir.
PPT visible?
వినపడుతుంది. Yes,
Okay,
sir.
okay. Thank you, sir. Comes under copyrights. What is copyright? Yeah, in previous thing we are discussing in what is copyright and copyrights early how to create a copyright act and how to initial days how to create and copyright mechanism and those things. But right now we are discussing in deeply what is copyright. Copyright, what is copyright? Here, copyright law protects original works of authorship fixed in a tangible medium of expressions to meet the standard of originality required under copyright law, along with the act also. And author need only demonstration of modest degree of intellectual labor in this case. A work is fixed when it is embedded in a tangible form that is perceptible by the human senses, either directly or with the aid of vision case. Generally, what is the definition of copyright? Copyright is a legal term describing the rights given to creators for their literacy and artistry works. Copyrights are set of exclusive rights granted by law to the creators and producers of forms of creative expression such as literacy books, music, and cinematography, and telebroadcasting works also. And so many already we are discussing so many territory conventions also there. Paris conventions and Brane conventions and Rome conventions and Geneva convention and Brussels convention and WIPO Corporate Treaty Act also there. Based on every convention, they give the particular mm, importance of the work. The importance of the property was first recognized. It gives the production of industrial property of the work, copyright work. Next, the Brene Convention in 1886, the first production of literacy and artistic works, both treaties and administered by the WIPO. And Rome Convention in 1961 to protect our performers, phonograms, and broadcasting mechanism. And broadcasting mechanism means TV broadcasting and online broadcasting and YouTube broadcasting. So many things also there. Yeah, when you are uploading any video in YouTube channel, some broadcasting layers also ask like you have no copyright issues, you have no broadcasting issues. Okay, this is the convention. Next, Geneva Convention in 1971, protection of procedure of programs against duplication of their phonograms. And Brussels Convention 1974, the importance of distribution of program carrying signal transmitted by the satellites. This is completely belongs to wireless communication technology, Brussels Convention in 1974. And we know that WIPO Corporate Treaty in 1986. It's provide the production of computer programs and forms of expressions. And copyright works that can be copyrighted. First one, literacy and musical and artistics and dramatic and recording. Here, literacy works means books and papers, research papers. Many one knows papers, research papers, next white papers, yellow papers, and green papers also there. And musical instrumentation gives the some categorical and give the musics. It gives the copyright. And artistics works means 3D imaging, 3D imaging, and cartoon works comes under Copyright Act, and dramatic as memes and all comes under Copyright Act, and recording also comes under sound recordings or songs and in movie. So many things are comes under Copyright Act. First one, First one, copyright of entire movie film processing. Okay. Second one, movie sound recording also uh, comes under Copyright Act, and some designer designs. Mahesh Babu also design his own interest. So many, even Rowdy Babies and Vijay Devarkonda gives Rowdy stores. And in Chiranjeev also maintained one thing like the same process. Okay. Then subject matter of copyright. The 10 enumerated categories are as follows. The first one, literacy work and musical works, including accompanying words and phonetic sounds like this. and dramatic works, including accomplishing music and choreographic works. Next, pan- pantomimes and pictorial graphics and sculptural works and poems and motion pictures like Tom and Jerry and so many things are there now. Audio visual works, video visual works, and sound records and architectural works like AutoCAD works comes under AutoCAD and design layout, building design layout, and design story like story, script story. Any story comes under building design layout, building plan. All are comes under architectural works and subject matter of copyright. Here, copyright, you know that book Alan, that means J.K. Rowling shows a written book, Harry Potter series, and subject matter of copyrights, music, a musical work of combination of composition may be in the form of a recorded copy, such as sheet music, or given a phonorecord, such as record cassette tape or CD, or DVD, or now online mode also. Next, memes, dramatic works, including application music, with music and without music. It is usually a theatrical performance. Memes are plays performed for stage, movie, television, or radio. You know that the show completely comes under Copyright Act and subject matters of copyright. Photo memes, pantomimes. Pantomimes are generally called as mime. Is a performance using gesture and expression to communicate with no accomplishing sound. Subject matters of copyrights. Choreographic works also comes under Copyright Act. Already you know that D show completely comes under copyright. And subject matter of copyright pictorial and graphics and structural works. These works, including two-dimensional or three-dimensional works, are fine. Graphics and applied also art also comes under Copyright Act. One thing, if you want check yourself, go search in Google, write anything, image like flower image, right, and check search. Yes. Some description also there in brown. May be copyrighted. This image may be copyrighted. Okay. Next, subject matter of copyright motion pictures like cameras comes under a motion pictures is a audio visual works consisting of series of related images that when shown as successive imprints or impression motion together, movies comes under completely movie, audio recording, video recording, everything comes under Copyright Act. And subject matter of copyright, your audio visual works like your voice also, if you want to create your Copyright Act, copyright based on your voice, that comes under Copyright Act. That is audio visual works, and audio visual works is a work consisting of serial of related images and internet may be shown in the use of machines or devices such as photo projectors, viewers, or electronic equipment together with accompanying sound, along with the subject matter of copyright. Sound recording, like music sound recording and songs recording, comes under Copyright Act. Subject matter of Copyright Act. The architectural design layout, like building plans and dams Whatever it may be, everything comes under CAD CAM works comes under completely Corporate Act. And principles of Corporate Act, these are categorized into four various factors. The main thing is the law for owners' rights. Second one, the original scope of copyright. Next one, expanded scope of copyright. These are things. Next one, text determine the copyright and public domain works. The public domain works means YouTube works comes under public domain works. Okay, website comes under public domain works. In every website given below copyright symbol, principles for copyright law, if no exception, seek permission. In academia, the three major exceptions to the copyright owner's right to control the reproduction and use of works of authorship are there to fail the exception, library of exception, and the face-to-face teaching exception. The face-to-face teaching means we are teachers now, we are professors. We are giving the exception of Copyright Act. If we are dealing with the digital, it comes under Copyright Act. Penalties. The penalties for a copyright infringement are too much harsh. It is an punishable offense also. It is a punishable criminal offense also. These are my copyright grants. This is my innovation of intellectual. This is the innovation of my in IPv16 Internet Protocol version 16 copyright grant from USA and American grant for in, in- grant for Internet Protocol version 16. This is the Indian grant for Internet Protocol version 16. Okay. Next, how to file a registration copyright. I'm visible.
Yes, sir.
Sir, time is అయిపోయిందా?
Yes, sir.
సరే దీంతో క్లోజ్ చేస్తానులేండి అయితే.
Okay, sir.
Copyright registration. Visible, sir?
Yes, sir.
Visible?
Yes, sir.
Copyright registration, you know that already what is the copyright and advantages of copyright registration. Registration required before a copyright owner bring suit for infringement, and who may file an application form. First one, author, copyright applicant, owner of exclusive rights, like if you want to file another one, through another one, like consultancy, like authorized agents such as author, other copyright element, or owner exclusive rights, any person authorized to act on behalf of the author, okay, and a list of creative works protected by the copyright law in India. Copyright formalities and registration, copyright formalities and copyright registration, uh, and so many registration process. Copyright registration process based on step-by-step formalities. If no objections are required, forms are first fill form 14 application for registration, copies of your work enclosing 3 copies, fee disclosure 500 rupees for registration, and disperse after filing attach all those things, submit from your end in digital way, then attach your work along 3 copies of your work along with your printed copy of your application, examination in corporate office, verify it is already or not or copyrighted or not, and any objections are required through through go through information through appellate board. Finally, if you are doing very good way, then grant of corporate registration of certificate. In the way, corporate registration another way. Corporate registration form it is any other mode. Examination in corporate office, verify it is verifies it is already there or not through corporate database through Viper PCT, USPT, PCT, and many things. If objections are occurred, call for objection overcome and information given through letters and reply for their originality and proof for works and discretionary if any discrimination is rejected and finally secure the grant. This is the corporate registration workflow. First, filing of application along with fee DD or IPO. If you want file with DD like offline mode, go through DD. Filing with application go through online through IPO Indian Patent Office. Where issued they issue diary number and 30 days mandatory waiting for objection. If objection is occurred, yes, then objection filed, some sending letters and reply from both parties, hearing for by registries, application is accepted, then go to application process, application accepted, then application accepted, then scrutinized by examiner, finally discrimination is given, finally give the registration approved by the registry of corporate director, then finally give the registration approved, sending the extract from this kind of certificates. Already shown certificates. This is the system. Legal service, how to corporate registration process. This is the mechanism. Filing of corporate application along with prescribed fees, along with form number 14, and once acceptance of registration, diary number issued. The diary number is after that mandatory period for 30 days, laterally scrutinized by the examiner along with patent scrutinizer also. And if your work is completely novelty, give the disciplinary clearance letter and finally secure the registration approved and certificate issued through speed post. But right now no speed post is given, no physical certificate is given, completely digital mode. Certificate sent to the sends from the like office. Finally complete the process and automatically save your certificates along with the filing process. Anything corporate registration agents also there. So many things in Canada, Kenya, every country maintained corporate office. US corporate office are also there. In India, corporate office in New Delhi and duration of corporates. Corporate stamps based on authors life plus life are 60 years or maybe in India 70 years plus or life entire life. The fee details of corporate registration for per based on your work, the registration fees also there. This is very nominal fees, government applied fees. Corporate registration form it is registration and after you um, getting the grant, then go to if you want to go to renewal, then renewal fees also there 200 and once corporate notice also there if you someone utilized your work without any without any without proper permission from your end, then go to corporate notice and corporate deposits also there for various requirements. Hello.
సార్
Sir, thank you. మీరు క్లోజ్ చేయొచ్చా?
మేము మా వర్క్ ఒకటి ఉంది కదా సార్, మేము అంటే అవుట్ ఆఫ్ థ్యాంక్స్ చెప్పుకుంటే మాకు మీరు
అదే ఇక్కడ
ప్రోగ్రామ్
ప్రజెంట్ నేను స్టాప్ షేరింగ్ చేయొచ్చా?
స్టాప్ షేరింగ్ చేసుకోవచ్చు.
సార్ సారీ, ఇంకా చాలా టాపిక్స్ మిగిలిపోయాయి.
నిజమే సార్, యు ఆర్ వెరీ ఇంట్రెస్టెడ్ టు గివ్ ది మోర్ నాలెడ్జ్ ఇన్ లెస్ టైం, బట్
అంటే యాక్చువల్ గా ఫైలింగ్ ప్రాసెస్ చెప్పాలి సార్. ఇంకా అది
మనం డూ వన్ థింగ్ సార్, మనం నెక్స్ట్ టైం ఆఫ్లైన్ లోకి వచ్చేద్దాం. ఇప్పుడు మేనేజ్మెంట్ తో కూడా నేను మాట్లాడాను,
సార్
మాట్లాడితే ఒకసారి పిలిపిద్దామండి వన్ డే కంప్లీట్ గా, పిలిపిస్తే ఇంకా బాగుంటది కదా, సార్ కూడా కొద్దిగా ఇంట్రెస్టింగ్ ఉన్నారు అన్నారు. సరే సార్, అట్లా చేద్దాం, ఏముంది.
షూర్ సార్, థ్యాంక్ యూ వెరీ మచ్. ఎనీ డౌట్స్? ఎనీ డౌట్స్?
నో సార్.
థ్యాంక్ యూ వెరీ మచ్. సార్,
This is the time to vote of thanks. My sincere thanks to management of Srivastava Institute of Engineering and Technology, principal and HODs. Without the coordination and the cooperation of R&D cell members, this program will not happen. The special thanks to my dear research coordinators, and thanks to all, and my heartful thanks to today's research person, Sambana. Bosubabu, this is the heartful thanks for you, sir. You
thanks.
gave the lot of information in less time. I hope that I will give the guarantee these people, my students will enhance this one, and they will use in future endeavors also.
Yes.
I hope this continue your help. I hope this will continue in future also, sir.
Thank you very much,
I'm
sir.
expecting in future also, sir. Thank you, sir.
Thank you.
Okay, sir. Close this session,
Thank
sir.
you. Thank you, students.
Okay, sir. Thank you.
Okay, sir. Thank you, sir.
Yeah. Okay.